Mr. Durst is present with Mr. DeGuerin and Mr. Chesnoff. We have Mr. Lewin Milius. Balin and Miata, you may resume your examination.
Bob, I started to ask you about other monies that you had given to Susan over the years, and you had started to talk about when Paul Kaufman was and Susan were planning on the musical. What about you? You said that was the one disagreement you had about money. Tell us about that.
Paul Kaufman said that he wanted me to put up quote-unquote seedling money, 10% of the total budget, and that would give Paul Kaufman the opportunity to raise the rest of the money. Paul Kaufman explained to me that the total budget was $5 million and that he wanted me to put up $500,000. I told him he was out of his mind and I would give him $25,000. He said that's a very small amount. And Susan sort of gotten in the middle of it all.
When was that?
In New York.
No, that's where. When was it?
$1998, I guess.
Okay. And did you give Susan or Paul Kaufman the $25,000 you promised?
I did.
Did you expect to ever see it again?
No.
So, when Kathy disappeared, Susan became your spokesperson for a while after that. Is that right?
Correct.
But did you have any contact with her from January the 31st until during the week after Kathy disappeared? In other words, before Kathy called the dean. Did you have any contact with Susan before that?
My first contact with Susan was on Wednesday, February 3rd.
So was there anything that Susan had to blackmail you with?
No.
All right, back to a sequence of events. You get to San Francisco. You leave the car at the airport someplace, maybe even running. Ordinarily, did you make reservations for your flying, for your trips on airlines?
No, I had no reservation.
No, I know you didn't for this one, but ordinarily, was that your habit? Or did you usually have reservations and make reservations?
Well, yes, I usually made reservations in advance.
Did you have any reservations in advance to go from San Francisco back to New York?
No.
How did you do it?
How did I do it?
Yes.
I left the car at the terminal right in the front. I walked into the first airline I came to, which was American Airlines, and I bought a ticket.
Did you travel under your own name?
Yes.
And when did you travel?
The plane left at approximately 10 o'clock and arrived at around 5 o'clock in the morning on the 24th.
Is that what they call the red eye special?
Yes.
All right, where did you go when you got back to New York?
Well, I called up Debbie to confirm that I was going to spend New Year's Eve and the next week or two with her at her house in Bridgehampton. And we got into an immediate argument about something or other. So I decided not to go to Debbie's house in Bridgehampton, but to go to my house in Ridgefield, Connecticut.
Did you do that?
Yes.
So where did you spend the next few days and next few weeks?
Well, the next few days I spent in Ridgefield, Connecticut. And then on December 29th or 30th maybe, I went to Palm Beach, where a friend of mine was having a big New Year's Eve party. And I stayed in Palm Beach for 2 or 3 days.
When did you return to Galveston?
Probably not until March or April.
In the meantime, were you in New York?
Or in San Francisco.
Had you heard anything more about the investigation that Janine Pirro had been running in November?
No. As a matter of fact, the next thing I heard about Janine Pirro was the wonderful news that her husband was going to federal prison for tax evasion.
So when did you decide to return to Galveston?
I have said in March or April.
And why?
I don't know.
When you returned to Galveston, did you wear the disguise, the wig, and so forth?
No.
When did you give up that disguise?
Sometime in January.
So when you got back to the apartment that you'd rented in Galveston, did you run into Morris Black?
I was there for about 3 weeks, and I saw him 1 or 2 times.
When you saw him, were you disguised or were you just Robert Durst?
No.
Did you make any acquaintance of him? I mean, did you say hello? Tell the jury what happened?
Well, not much happened. We did some things together, but nothing particularly special or important.
Well, when you say you did things together, when was the first time he saw you as Bob Durst? And not as Dorothy Siner with a wig?
Sometime in March or April.
All right. Did he make any remarks about that?
I told him that I sometimes wore a disguise as a woman because I just did not want to be me. And he said he went through that a while ago.
In other words, not wanting to be you, not wanting to be Bob Durst. Did you explain to him why? You didn't want to be Bob Durst?
Primarily because of Janine Pirro.
And you say you did things together. What did you do together?
There's not that much to do in Galveston. We went to the gym a few times. We went to, can't remember the name of it, but it's a big bookstore that also sells CDs and DVDs and software. I think it's called Harrington's. We went there a number of times.
All right. And did you have a car there?
Yeah.
What did you have?
Yes.
What did you have?
I had a Honda CRV.
And that Honda CRV, was it registered to Bob Durst?
Yes.
What did you do for money during that time?
I would withdraw money from my Bank America account.
Bank America account in what name?
My name.
Bob Durst
Yes.
or Robert Durst.
Yes.
And where would you withdraw the money?
They had a big branch in Galveston.
Did you have identification that showed that you were Bob Durst?
My Texas driver's license.
When had you gotten your Texas driver's license?
I think I always had a Texas driver's license.
Well, always is a long time. When did you
Well,
first get it? When did you first get your Texas driver's license? If you remember, not the date, but close in time.
Probably in the early 1990s.
Okay. At that time, did you have an apartment in Dallas?
Yes.
All right. We've talked about guns. You had no gun in New York, is that right? I mean,
Correct.
handgun.
I only had a gun in Texas.
I think we went over that the New York laws are very, very stringent about handgun ownership. Is that right?
Yes.
So, when did you first get a gun in Texas, a handgun?
Well, I had it in Galveston when I was arrested.
Yes, I understand that. When did you first get a handgun in Texas? When and where?
Well, it depends where I was. When I was staying at the apartment in Dallas, I had it at the apartment in Dallas. When I was in Galveston, I had it in Galveston.
Tell us about how, what you thought about guns.
Well, when I first started doing business in Texas, in Dallas, in 1986, one of the brokers invited me to go to a shooting range, which I did, and I enjoyed shooting, so I bought a gun.
And you say a shooting range. Where was the shooting range?
Well, in Dallas, it was on Preston Boulevard.
What kind of gun did you have? What kind of handgun did you have in Dallas?
A pistol.
When you say pistol, does that distinguish it from a revolver?
Yes, the other kind of handgun is a revolver.
All right. And you said you also had a gun, more than one gun, in Galveston. What guns did you have in Galveston?
Well, I had the 9mm pistol that I had when I got to Galveston. And when I first became friendly with Morris Black, and he told me about this place where you could go shooting in Galveston, I had bought a .22.
Let me stop you there. The first gun that you had in Galveston was the 9mm?
Yes,
Where did you get that gun and when?
probably in the early 1990s.
Do you remember where you bought it?
No,
Was it in Galveston or Houston, in that area, or in
no,
Dallas?
I did not know Galveston back then. It was someplace in Dallas.
Okay. A gun store?
Yes,
And when you bought it, did you buy it under your name, Bob Durst?
yes.
Okay. And so when you came to when you came to Galveston for the first time, did you bring it with you?
Yes,
So I want to talk about that 9mm and Morris Black. How did Morris Black learn that you had a handgun?
probably I told him.
Did he seem interested in that?
We were at Harrington's looking at magazines, and he was looking at a gun magazine. And I remember telling him that I had a gun.
Okay. And the kind of gun, it's one of the guns that's in evidence here, a 9mm Browning semi-automatic.
I don't know what the question is.
Okay. The gun, the 9mm that you had in Galveston, was it a 9mm
Yes,
semi-automatic Browning?
I don't know about Browning, but semi-automatic, yes.
The one that's in evidence here?
Yeah, I guess.
Okay. It's the one that you were arrested with in Galveston?
Yes,
All right. Now, you mentioned that Morris Black was reading a gun magazine. You said you had guns, and then what happened? Take us from there. About
we talked about going to a shooting range, and Morris Black said he did not like shooting ranges, but that he knew a place out by the water in Galveston where one could shoot.
Had you been to shooting ranges in or near Galveston?
Yes,
Where?
Carter's Country,
Where was it located?
a town called Pasadena.
Is that a suburb of Houston?
Yes,
Okay. Is it close to Galveston?
halfway between Galveston and Houston.
All right. So Morris said he didn't like shooting ranges, but he did know a place near Galveston where you could go. Where was that place?
Hard to describe.
Do you know the name of it?
Well, I guess I don't. It was there was a park whose name I've forgotten, and on the way to the park, there was a dirt road, and if you went down the dirt road, you came out by the Houston Ship Channel.
If I were to say the name Seawolf Park, does that ring a bell?
That's it.
And just so we can understand why it's called Seawolf, is there an old World War II submarine that's named Seawolf that's based there? If you know.
I have no idea.
And is that place actually a separate island from Galveston Island, a smaller island called Pelican Island?
Correct.
Okay. Was there any development, like houses or buildings or so forth, on this road that he directed you to?
There's nothing there.
So describe the surroundings. What's it like?
Well, you've got the Houston Ship Channel on one side of it, and some low brush on the other side of it. There's nothing there.
All right, no people.
No people, no buildings.
So did you and Morris go there to shoot your 9mm?
So we went there to shoot, and it quickly became apparent to me that Morris was not familiar with the 9mm because he would shoot a whole magazine real fast without taking into consideration the kickback. So I felt that he was dangerous with the 9mm. So I only let him shoot one magazine. And I told him the next time I went to Houston, I would buy a .22 caliber pistol that you could use for target shooting.
Did you do that eventually?
Yes, probably a month later.
Okay. Now, in the meantime, I want to let the jury know a little bit about the relationship that you had with Morris Black. How did that relationship develop?
We did stuff together.
What kind of stuff?
Well, as I said, in Galveston, there's not much to do.
So what kind of stuff did you do?
We would go to the beach. We went to the gym periodically. We went to Harrington's twice a month. They had art nights, and all the little touristy stores would stay open at night, and we would go to the art nights. Several times we went to the movie theater on Galveston Island.
Did Morris Black have any other friends in Galveston that you saw?
Yes,
Who?
I don't know their names. One man that he was very friendly with owned a little grocery store, and Morris was able to get telephone calling cards virtually for free.
Did Morris have problems with people in Galveston?
He would get into arguments
Objection.
with
Prior
everybody.
rulings, Your Honor.
Sustained. Stricken.
Motion to strike the answer.
Stricken.
Thank you.
Well, did you have any reason to be concerned about Morris
Your Honor,
being
the court had
violent?
previously told Mr. DeGuerin to approach on this
No.
issue.
don't object that
May
way.
we approach, Your Honor?
Yes. Ladies and gentlemen, this is such a good issue we're talking about. We need to talk about this more. So we're going to excuse you for till 11:15. Okay? We have another break. Do not converse among yourselves or with anyone else on any subject connected with this case. Do not form or express any We're now going to have a hearing on the issue of the admissibility of alleged misconduct by Morris Black. The people are objecting and the defense wishes to introduce testimony by Mr. Durst of things that Morris Black did that were violent. The theory of this is I guess there's a dual defense here on the homicide of Morris Black, that it was an accident, and also it was in self-defense. I guess self-defense during an accident, or accident during self-defense. Either one could raise a reasonable doubt, right?
He was defending himself by wrestling with Mr. Black over the gun, and the gun went off.
All right, so that's not intentional, that's an accident.
But, Your Honor, it's
Yes.
also for the limited purpose of us refuting the people's position that Mr. Durst willfully killed Mr. Black because Mr. Black was another person that they consider to be a potential witness against Mr. Durst. Actually, that's the reason they got Galveston in, was because they had a theory that somehow Mr. Durst could be identified. Mr. Durst is allowed to express his state of mind about this man, which is that he was afraid of him, but not afraid of him because he would be a witness, afraid of him because he was violent, he posed a threat, and he responded accordingly and lawfully when Mr. Black pointed a gun at him. But they can't leave hanging out here this argument that they're going to make to the jury that the Black death was as a result of Mr. Durst being afraid of him because he was a potential witness. Mr. Durst is entitled to tell the jury the reason why he shot him, and it had nothing to do with Mr. Black being a witness against him.
Right, and so I understand that the testimony is, or will be, has been, that Mr. Black pointed a gun at Mr. Durst, which is, of course, if true, he has every right to defend himself in that situation, regardless of anything else. And wrestling over the gun, he could take the gun away. He could even shoot him intentionally in self-defense, I suppose, if his life were in danger, and one's life is endangered by a gun pointed at him. Now, the theories of admitting this evidence of wrongdoing would be twofold. One would be that Mr. Durst would have a fear of Mr. Black because of his belief that Mr. Black was dangerous based upon prior incidents of danger. So, but as in Chambers, the problem with this is that sort of explains and justifies defense against ambiguous behavior, but pointing a gun at someone directly, regardless of their past, regardless of these bad acts, you would have an absolute right to defend yourself. So the problem with admitting the prior acts of violence is that it tends to denigrate the victim without any consequence for the self-defense claim, the second, or the accident claim, and both serving to refute the people's theory. So what we really, and so under 352, I would exclude that evidence. It's more substantially more prejudicial than probative. However, there is then another theory, and that is 1103 of the Evidence Code, which allows evidence of prior violence by a victim or evidence of the conduct of a victim to prove conformity therewith on the date in question. So if the jury perhaps didn't believe this story that that Morris Black pointed a gun at him, they would only need to look to this evidence to see that indeed that was his character. He had a character of violence, and Mr. Black was acting in conformity therewith. This is a believable and plausible account. And so then the question becomes, then we have another, assuming that that's valid, we must look at a couple of things. One is that evidence substantially more prejudicial than probative? That's what the people are going to suggest. Secondly, if it is admitted, 1103B provides for the people with virtually without limitation, 352 limitation, but evidence otherwise excluded of other prior violence by Mr. Durst would now become admissible to prove, to rebut that evidence and to show that he was indeed the aggressor in Galveston. So that is the problem for the defense. But as I understood, you're willing to take that risk that Mr. Lewin would be able to present even more evidence of violent conduct, and then I would instruct the jury, ladies and gentlemen, you have heard of this violent conduct. You may consider it to determine whether or not Mr. Durst acted violently, that he indeed was the aggressor in Galveston.
Well, Your Honor, it would be nice, most respectfully,
Yes.
to have seen what this other crime evidence is, because all we've heard so far is that he's got other information, but I'm not remembering it in the discovery, number one. And number two, this question of whether it's more prejudicial and probative can't be taken in a vacuum, because the court, we're not dealing with a situation where they're fighting the question of self-defense or not. We're fighting the issue that they've raised. The only reason that the court permitted the Morris Black acquittal to be brought into evidence and the pictures of the body is because, according to Mr. Lewin, Mr. Durst did what he did not in self-defense, but because Mr. Black was a threat to him as a witness. So you can't just look at the more prejudicial and probative without examining the fact and the context that it's in, and that's based on their presentation of the evidence.
No, probative means of the point you are trying to make. In other words, your reputation is what it must prove. So when I look at whether it is probative, and it must be substantially more prejudicial than probative for me to exclude it. All relevant evidence is presumed admissible in California. Exceptions are 352 is one of them. So please identify for me what are these acts that you wish to describe, and they are all according to Mr. Durst only, right? There's no independent proof of this. It's not like you're introducing crime reports or witnesses to his violence. This is Mr. Durst's version of Mr. Black's past, a history of violence according to him. So go ahead, tell me what it is.
I'm sorry, I was distracted. I think Mr. Chesnoff asked for an offer of proof about what other acts, if there's any other acts of Mr. Durst that they want to bring in under 1101B.
1103B.
1103B, then we don't know what they are. It sounds like to me everything's already in.
Yeah. In other words, Your Honor,
Is there something else we don't know
we
about?
could cut this short. You've asked us a question. Do you want it? Be careful of what you ask for.
Yes.
Okay, I'd like to know what it is that we're going to get before I have to answer that question.
All right, so there's two categories, Mr. Lewin. One is things that have not yet been presented in evidence. Secondly, the question is how I would instruct about things like the assault on Peter Schwartz, the assault on the Berkeley traffic officer, and that sort of thing. They may take it in a different way, given the admission of this. So tell me, though, the question is the things we've not heard.
Wait, Your Honor, before we go there, because what the defense is basically doing, we have to go back to the beginning. This is extremely important. This is the foundational question before we get there. 4 years ago, the court gave us deadlines on motions and when they were due. Repeatedly in court, the court has said motions due at this point in time. I can give the court's well aware, the court literally stated to the defense more than 2 years ago, if in the future you bring up an issue that is a surprise, that you are unaware of, that you did not choose to litigate, that is one thing. But if you simply did not file a motion, did not bring the issue up to litigate, then the presumption will be that that motion will be denied. So the first issue, Your Honor, is they have been aware and they've been talking about Morris Black for years, and there's not one motion. The second issue, which relates to that, is I made clear, because I don't trust Mr. DeGuerin to follow the court's orders regarding what he can and cannot do. So I made clear, Your Honor, 3 different times in the last 2 weeks, I brought up this issue of Mr. DeGuerin going into things that he's not supposed to go into. The court literally, and I don't know that we were on the record or whether we were just in chambers, made very clear to Mr. DeGuerin, which he said, if you intend on doing anything relating to Morris Black's prior conduct, you will ask to approach and we will litigate it. So what happens today? They go, and he asks a question. I object. The court sustains the objection, and he simply asks it again. Now, obviously, and I will apologize to the court, that resulted in a speaking objection from me, and obviously, I was extremely angry, because in essence, what Mr. DeGuerin is saying is, I don't care what the ruling is regarding whether this information can just be brought up without approaching. I'm going to do it anyway. So the first issue is, Your Honor, which again, this was the court's instructions, not mine, is how on earth can they justify? We've been in trial for months and months and months. Mr. Durst is on the stand, and without a motion, without approaching, without anything, they bring this prior violence up. That's number one. Number two, there are a number of different areas, and just to refresh the court's recollection, if you remember during opening, Your Honor, I went livid because, again, against the court's prior instructions, Mr. DeGuerin put up, if you remember, a mugshot of Morris Black from South Carolina. Literally a mugshot with his numbers on it. It was inappropriate. He knew it was unethical. He did it anyway. I'm not going to mince words. I'm not going to pretend that, well, it's just gentlemanly, etc. It was a slimy thing to do. He knew it at the time, and he did it. We went into chambers. The court said, you can't do that. The court said, you can't use that. And what that was is, it was an allegation, if the court remembers, that they had gone back and found out that Morris Black had had some disagreement with the utility company in South Carolina, and that allegedly there had been some threat regarding his, and I don't have it in front of me as I sit here, because again, since the defense did not do what the court said and file a motion listing specifically what acts they want to get in and what they don't, I have to go by my memory. So that's the South Carolina incident. Another incident that they put on in Galveston was when Mr. Black was in the hospital, at times not knowing what was going on. He was under all kinds of medication. They had to strap him down because he was, in essence, delirious and being hostile. The defense put that on to try to argue that somehow that demonstrated Mr. Black's violence. It was not objected to at the time. It was not litigated. It's absurd. He's in a hospital. It does not relate to anything remotely concerning this case. They then brought up the issue of the Galveston library. And as everybody knows, Mr. Black is a very cantankerous old man. And he got upset about certain of the library policies and was very vocal about it. And in essence, they had to get a stay-away order from the library. Mr. DeGuerin now attempts to turn this into stories about Mr. Black's violence, which of course, I'm not in a position to really respond to because he hasn't put anything in writing. He hasn't submitted any motion, so I have to go by my memory of what he did at trial 17 years ago. So now we get into the final issue. And it's amazing. The defense has the gall to stand up here and just say, well, Mr. Lewin, you haven't told us, you haven't provided the discovery of what incidents you would use to impeach us when we bring up something that the courts told us we're not allowed to bring up. The answer to that would be, when I get a motion that says what they want to put in, I can respond. But the court's absolutely right. And this is the problem with Mr. Chesnoff's offer. The court has admitted the evidence under 1101B, and the court was extremely diligent and extremely thorough in laying out all of the reasons why all of this evidence came in. And it was not, as Mr. Chesnoff just characterized, it was not for one reason. It was for multiple reasons why all of the evidence regarding Morris Black on our side has come in. So the defense is now thinking, and the court pointed out, and it's true, wait a minute, how much stuff is really out there that they can bring in? Off the top of my head, there are a couple of other incidents. There's another incident involving domestic violence with Kathy that I did not bring in. There is a fight with Douglas Durst where Mr. Durst came at him with a very large weapon in the office, and Douglas had Bob had an offensive weapon, and Douglas had some kind of like shield thing that he was able to block. They did not end up actually having the actual struggle, but Douglas Durst found that Bob had this weapon and became very concerned. He got himself a shield weapon as well. There are some other incidents which I have to go back and take a look, but the court, absolutely correct. The other problem they're going to have is right now, the court has given a limiting instruction regarding how the 1101B evidence is to be used, meaning the 1101B evidence of violence. Number one, the defense doesn't have the right or the legal authority to be able to say, hey, listen, we don't care about relevance or 352. Because if you look at it, and this goes back again, Your Honor, to the point, I made this in chambers, and I think the court has indicated the court agrees with this point, that the defense in this case is that Morris Black pulled a gun on Bob Durst. It is not even arguable when a person pulls a gun and is pointing it at you. It doesn't matter what you believe their prior history is. It doesn't matter what you know about their prior history. At that point in time, when a gun is being pointed, you are in imminent danger and you have a right to defend yourself. It is even more problematic for them because in the end, they're not saying that Bob Durst shot Morris Black intentionally, which if you look at how self-defense and mental state works, the idea would be that I was confronted with a situation where I was in imminent danger and I then had to defend myself. I'm realizing I'm talking fast, so I'm going to slow down. I then had to defend myself by using lethal force to stop that imminent threat. Now, the problem is that generally comes up, and where self-defense becomes an issue, is where, as an example, you have a gang member A, and you have gang member B. And gang member A says, I saw gang member B coming down the block. I knew who he was. He got out of the car. I saw him reach behind him, and at that point in time, I thought he was going for a gun, and I shot him. His mental state and his understanding of what the guy's history was who had whatever behind his back is relevant, because at that point in time, he's got a right to defend himself. In this case, they are not even arguing that, number one, the act was deliberate, meaning that he intended to kill Morris Black, and that, number two, it strains all credibility how it could overcome a 352 objection when, in the end, either Morris Black pointed the gun and was threatening to kill him, or he didn't. If the jury believes Bob Durst, I don't think they will, but if they do, that's obvious self-defense. The next issue, which is related, is that the majority of the stuff that I'm aware of that the defense wants to cite. So as an example, the idea that Morris said that he killed a soldier in the Merchant Marines 40 or 50 years before the incident. Number one, there's no evidence of that other than Bob Durst's statements. Bob Durst has repeatedly, during his testimony in this court over the last 3 days, he has perjured himself probably 100 times. And that's not hyperbole or me arguing. He's perjured himself because he has testified inconsistently with other statements he's given under oath. They can't both be true. He's basically said in the past, I didn't go there. And today he comes up and says, yes, I went there. So the court, even in looking at the relevance of this and whether it's going to overcome the 3-2 objection, has to look at the trustworthiness of the evidence. So the first thing is any evidence that's coming from Mr. Durst, in and of itself, that is not corroborated in other ways, doesn't pass the test. Number two, most of that information that he is giving, we believe falsely, even if it occurred, which there's no evidence that it didn't, it would not be in any way timely, meaning that it's remote. We're talking about 40 years prior, etc. Number three, the incidents that they want to discuss, which relate to the thing in South Carolina, the medical treatment in the hospital, the incidents on the beach where Bob Durst snaps at people about throwing balls, etc. Simply, in this case, when you look at what their relevance will be, given what the other evidence is, it just doesn't pass 352. And then, of course, Your Honor, and I don't think this is a minor issue, they chose to deliberately not litigate this motion in advance. That was a tactical decision on their part. Your Honor, we know it's a tactical decision because I brought up this issue of the violence over the years, Your Honor, probably 15 times in open court. I've said, where's your motion? What are you filing? They don't do it. So for all of those reasons, Your Honor, under relevance and 352, none of this should come in. Now, finally, and this is important because the defense has been saying repeatedly, one of the big issues that they've argued, Your Honor, with respect to 1101B with Morris Black is they've said, listen, there's no evidence whatsoever that Morris Black knew anything about Bob's situation in New York. Well, Bob Durst just testified that he discussed the situation involving Janine Pirro with Morris Black. So unintentionally, Bob Durst has just proved our point for us that Morris Black was obviously aware of the situation in Galveston, in New York, that Bob Durst was potentially facing charges there, and that he was afraid of being charged by the district attorney at that time, Janine Pirro. So for all of these reasons, Your Honor, and I can't even figure out which is the most important one, they don't make it. They don't make it under self-defense, they don't make it under 1103, they don't make it under 352, and they don't make it under the court rules, which the court said, and I'd be very interested, how can they justify? So what new information came out? This is coming from their client. This is a question by Mr. DeGuerin. Clearly he intended to get into this issue. Court said, unless you show good cause why you did not file a motion in advance, I'm not going to allow it. I think that's where we are, Your Honor. I don't know another way to interpret it.
Question. Seems all of these things sound familiar. Weren't they admitted in Mr. Durst's testimony from Galveston?
Yeah.
They're in the record already.
Yeah.
No, no.
Yeah.
There's
So
not
the question, yes, they were admitted in Galveston.
But
But here, when they were read to the jury, didn't the jury hear substantially these
Substantially
things?
less because the prosecution blacked it out, sure. But here, I can answer this pretty easily,
Yep.
Your Honor.
Yes.
When someone pulls a gun, whether it's pointed or not, if you think that someone's going to use it because of what you know about that person, that's your subjective fear based on the objective information. But if the person that pulls a gun against you, you don't think is going to use it because
Well,
you
if it's an
don't
accident-
fear that person, then it does make a difference whether you know, whether you believe that the person is capable of violence.
Well, it seems to me that if Mr. Durst testifies that he intentionally killed Mr. Black, then it comes in.
Testify to that.
It does come in for that to support his intentional killing of Morris Black, because it would be self-defense. Now, if it's not self-defense, if it's accident, then it doesn't matter, right?
No, but
No,
Your Honor,
the
this-
self-defense started when he started wrestling with him. That's why he's wrestling with him to take the gun away.
Wait, he
because fears.
shouldn't wrestle with it?
Yes, but that's the self-defense, Your Honor. The fact that the gun went off doesn't indicate that it's intentional.
Well, it's not lethal. Wrestling with someone's not.
But you can fight somebody if you know they're violent.
You can fight somebody whenever anyone points, if the Pope, with no criminal record, points a gun at you, you have a right at that point in time to defend yourself with lethal force.
I don't think the Pope would shoot me, and so I probably wouldn't. But if a gang member pulls a gun, whether it's pointed or not, then I've got more fear of that person using the gun than I would the Pope, if you, to use their example.
All right, but it seems to me that there's no testimony from him that he intentionally used lethal force, so it's not self-defense.
No,
it's accident.
that's just a deliberate misinterpretation that they're putting on you, Judge. That it started because of his fear of Morris Black when Morris Black came up with a gun. The wrestling then started, and as they wrestled and fell to the ground, the gun went off. His finger was not on the trigger. Morris Black's finger was on the trigger. He had a reasonable fear of Morris Black.
So he wrestled him.
Well, you know, to keep himself from being shot, of course.
And you need to prove that he's a bad guy in order for the jury to.
Well, but Your Honor, there's
Yeah, he wouldn't, if it was someone that he didn't think was going to use the gun, then he wouldn't wrestle with it.
Your Honor, why did Galveston come in? We filed a motion on that. We were pretty clear on
Well,
that.
I mean, the evidence seems to be that he killed him intentionally.
Right.
And I'm trying to help you out here.
I understand.
But it was self-defense.
We're fine with taking our chances with Mr. Lewin adding other alleged crime evidence, Your Honor. And I want to say this for the record, Your Honor. These ad hominem attacks on my colleague, Mr. DeGuerin, are so unnecessary. All Mr. Lewin has to do is make an argument. You know, we didn't come out here and make a record that Mr. Lewin violated your order, that he tried to influence the jury by a speaking objection. We didn't do that. But he has to, instead of addressing legal issues, make it personal. And I just don't understand it. He makes cogent arguments. When he stays focused on the law, this other stuff is a disservice to all of us and to the court, Your Honor.
I try to keep any admonitions to counsel private. You all deserve to protect your reputations. You're fine lawyers. So, all right, I'm going to look into the issue, move to another topic. It seems to me at this point it is substantially more prejudicial than probative when the defendant isn't even claiming self-defense. There's no basis to further defame Mr. Black.
It's not in defamation, Your Honor. It's to show Mr. Durst's state of mind when eventually Morris Black starts to point a gun at him.
And by the way, how do you defame a guy who's attacking you with a gun?
Well, exactly. I mean, that's the thing.
Well, but we're not doing it to defame him. We're doing it to explain his actions.
To
Except his
explain
actions are not
Mr.
relevant.
Mr. Durst's action.
In the end, what they're basically saying, Your Honor, the court's is very on top of this. What they're saying is, what is very clear, is Mr. Durst has a right to defend himself once Morris Black points a gun at him. There's no question. He's got a right to take the action that he took. He's saying, but by the way, it wasn't intentional. I didn't even intentionally shoot him. And they're saying, well, wait a minute though, we want to be able to muddy up Mr. Black to prove that Bob Durst had a reason to want to, I guess, accidentally shoot him. It's absurd and it's transparently revealed to be illogical. It doesn't work.
It's not absurd in the context of allowing a murder that he was acquitted of and the body parts to be presented to this jury for us to explain to the jury that Mr. Lewin's theory that somehow this came in because Morris Black was a potential witness against him, and in his last statement he said, oh, by the way, Bob's now acknowledged that he talked about Gene Puro. I promise you, you will hear that from him. And that's exactly why we're trying to present the full story to the jury, so that the jury understands it had nothing to do with Bob's fear of Morris Black being a witness against him. It had fear of a violent guy who pointed a gun at him.
All right, thank you. Let's bring in our jurors.
One other thing.
Yes.
Look, it's one of the oldest debate tricks in the world to mischaracterize your opponent's position, because that's easier to strike down. They're mischaracterizing what we're saying. We've said all along, we said in Galveston, we say it here now. When Morris Black came up with the gun, Mr. Durst knew enough about him to be reasonably in fear that Morris Black would use that gun.
Okay, well, I'm going to listen to Mr. Durst's testimony to see if Mr. Black pointed the gun at him, and if the shooting was accidental. I'm looking at that. I'm sustaining the objection, but I will do more research on it. I reserve my right to change my ruling. I'll let you know if I do that. Right now, objection sustained. Let's get the jurors.
I thought we came out for me to make a tender of proof with Mr. Durst on what he knew.
No, it doesn't. I think the whole subject is irrelevant, because it's the man pointed a gun at him, and he didn't even he could have killed him, but chose not to kill him. Instead, tried to push the gun away. It was an accidental killing.
That's not a choice. He was wrestling with him. He was trying to prevent his own death, and in that wrestling, when they fell to the floor, the gun went off because Morris Black's finger was on the trigger.
Well, then it's Mr. Black then who shot himself,
Oh, come on.
right? His finger's
No.
on the trigger?
No!
Whose finger's on the trigger?
His finger was on the trigger.
Mr. Durst's finger.
No!
Oh, okay, then he didn't shoot him.
Oh, Judge, come on. No, the gun went off because Morris Black's finger was on the trigger when they were wrestling and they fell to the ground, and the gun went off.
Accident.
Yes,
Beautiful. He may testify to that. That's a defense.
We'll have no objection
but
to
you
any of that.
you cannot separate what happened. You cannot take it in a vacuum. It happened during a struggle over the gun because he was concerned that Morris Black was going to shoot him.
Because he pointed a gun at him. I get it now. Objection sustained. You have other subjects to cover, quite a few. You're spending the day on this. You got a lot of material to go to.
I'm not going to.
Your Honor, can Mr. DeGuerin and I have a moment before you bring him, are you bringing him back in?
Yes.
Okay, well, I was going to try to help.
It's
Okay,
it's
fine.
35 minutes.
Okay.
Ready, Your Honor?
Yes. How much? What do you need?
I wanted to help Mr. DeGuerin move along, that's all, because you just...
Okay, you may speak. Yeah, hold him up for a minute.
Are we
Yes.
permitted, Mr. DeGuerin permitted to talk about Mr. Black firing the gun and any of that stuff, or is that out too?
He shot the gun twice in the apartment.
We don't, just so it's clear, we have no objection to them bringing up what we believe to be falsehoods about Morris Black shooting the gun in the location. It's fine. We certainly would have a legitimate argument.
There's no objection. Go ahead.
Yeah,
Okay,
no issue.
I just wanted to be clear on that. You're all set.
David, I've said, if you guys have an issue, if you ask me, I'll tell you. Most of the stuff I don't have an issue with, Dick. If you ask me, I'll tell you. That's why I stipulated your stuff this morning.
Okay, you ready?
Yes, thank you, Your
Okay,
Honor.
jurors, please. Oh, wonderful news. Thank you. Now I'm in a good mood.
So I have to write a research paper instead, you know.
Good for you.
Yeah.
Yeah. I was starting to feel all cranky, and now you're making me feel happy.
We can all help, we cannot.
Yeah, sure. Yeah.
Yes.
I missed that. We're going straight through the week.
We have to do some
Yeah.
work on a research paper.
All right, we're back in session. Our jurors and alternates are present. All parties are present. Defendant is present. You may resume your questioning.
Okay, we're in Galveston during the spring, summer, and coming up into the fall of 2001. Were you in Galveston all the time? Were you traveling, or were you in New York? Where were you during that period of time?
I sort of moved around. I spent time in New York and in San Francisco and a little bit of time in Galveston.
Okay, and when you were in Galveston, did you and Morris Black do things together?
Yes,
All right. I want to talk about a specific, well, first I guess we need to talk about the 22. Did you, after determining that Morris was dangerous with the 9mm in your view, what did you do about getting another gun?
about 3 weeks after I first went shooting with Morris at this open area near the park, the name of which I've forgotten already.
Seawolf Park.
Seawolf Park. I told Morris that the next time I was in Houston, I would stop at a gun store and buy a gun that was specifically for target shooting. And I did that. I bought a .22 caliber pistol. That was a very big gun, so there was almost no kickback.
All right, is that the .22 caliber Ruger target pistol that's in evidence here?
Yes,
I've asked the clerk to get it, and we'll have it in the courtroom before too long, hopefully before lunch. But in the meantime, where did you go to buy that pistol?
where
Yes?
there was a big gun store called Carter's Country. That's where I bought it.
There's several Carter's Country in Houston. Which one did you go to?
The one in Pasadena.
All right. And did you buy the gun under your name?
Yes,
By this time, which I believe is in the fall of 2001, had there been any action with Janine Pirro?
very infrequently. I would see her on a TV show, but she was busily trying to ignore the fact that her husband was in federal prison, and she was trying to run for Attorney General anyway. So she was in the press pretty frequently, but very infrequently would she bring up Robert Durst.
Okay. Now, once you got the .22 pistol, the Ruger .22 target pistol, did you and Morris Black go shooting?
We went shooting frequently, every other day, more or less.
Did he seem to get enjoyment from that?
Yes.
All right. Now, what was the situation with Morris Black having access to your apartment on K Street in Galveston?
I had given him the key sometime in the summer and told him he could watch TV whenever he wanted, as long as I wasn't around.
And were you frequently not around?
Yeah, I was not around most of the time.
Where were you?
San Francisco or New York.
Did you at some point get another apartment in New Orleans?
Yes. In the spring of 2001, March or April, I decided that even if Janine Pirro did not seem to be doing anything, I should have a place to go where I was not known as Robert Durst. So I did exactly the same thing in New Orleans as I had previously done in Galveston. I went to a wig store in New Orleans, got a woman's wig, called up an advertisement for an apartment, told them my friend was a mute woman and she wanted to rent their apartment.
You've heard evidence here, the jury's heard evidence that that man wasn't fooled at all by the disguise. Is that right?
That's what he said.
Okay. Also, I neglected to ask you about Susan's memorial. Did you go to Susan's memorial?
I went to Los Angeles for Susan's memorial, and then I spoke to the criminal lawyer in New York. He said, "You're making a mistake. You should not go to the memorial because the press will be there and you will turn the Susan Berman Memorial into a Robert Durst went to the Susan Berman Memorial story." So I took his advice and I did not go to the memorial.
But were you actually in Los Angeles intending to go? That is, did you actually travel to Los Angeles?
I went to Los Angeles.
Okay. But you didn't go?
I did not go to the memorial.
All right, back to Galveston. After you bought the .22 target pistol and you and Morris Black went shooting on a frequent basis, did you leave Galveston and come back unexpectedly one day?
I'm not sure. There were several times when I don't know what you mean by unexpectedly.
Yes. Was there an occasion in which you came to the apartment in Galveston and found that Morris Black was in the apartment?
Yes.
All right, I want to go to that first incident, and I want you to explain to us what happened.
I was urinating in the bathroom and I heard a shot. I assumed the shot, the noise came from outside, but I wasn't sure. When I got back into the apartment, when I got into the living room, Morris Black was standing there with the gun, pointing at a letter that was thumbtacked or scotch taped up on the wall. The letter was an eviction notice from the landlord. And Morris said, I shot the eviction notice.
Inside the gun, inside your apartment?
Yes.
All right, let's examine that for a moment. What did you know about the eviction letter before that happened?
Your Honor, could we have Mr. DeGuerin direct him as to time? I know Mr. DeGuerin knows the date, just for the jury.
Yeah, I'm trying not to be leading, but I'll
I'll allow it.
okay. Had Morris Black complained to you about getting an eviction letter from Klaus Dillman?
Yes.
Was he angry about it?
Yes.
So, give us an idea about when this was.
Probably August of 2001.
All right.
Your Honor, the question is vague, it's unclear. Is he asking about when the shooting occurred? or
No,
when
I'll get to it.
the eviction?
Clarify.
I will. Sorry, I believe it's in evidence. I just don't have I can't put my finger on it right now. I will after lunch. But you've seen that eviction letter. Put it in reference to September 11, which everybody knows, of course, in 2001 was when the attack on the World Trade Center happened. Let me concentrate on that. Where were you when the World Trade Center was attacked?
In Galveston.
Where was Morris Black?
In Galveston.
That was a day that everybody remembers, but what happened between you and Morris Black that day?
September 11th, 2001. I can't think of anything that happened.
Well, was Morris Black in the apartment watching television with you when the September 11 happened and all the aftermath occurred?
Well, I had invited him in.
Yes. To watch television?
Yes.
And what was his reaction when that happened?
He sort of flipped out. He was sure that the United States government.
Objection. Motion to strike is irrelevant.
It's non-responsive. Ask a different question, or ask the question again.
What was his reaction to all that?
Objection relevant, Your Honor, and 352 regarding his
Sustained.
objection.
Sustained.
Where was that in relation in time to when Morris Black shot the gun in the apartment the first time?
Morris Black shot the gun in the apartment. I believe in August of 2001.
Okay. What happened when Morris shot the gun in the apartment the first time?
Well, I got upset and I got angry. And I told him he couldn't stay in the apartment and watch TV anymore. And I made him give me the key back.
Did he give you the key back?
Yeah.
Did you notice that there was some damage to the apartment?
I did not notice right away. But within the next couple of days, Morris came over with the stuff you used, the spatula, spackle, I guess it's called. And they use it with drywall. And he said he would repair the hole in the wall where he had shot. And he proceeded to spackle it. Up until then, I was not aware that there was a hole in the wall.
Okay. Now, although it was by reading the testimony that occurred in Galveston, Max Courtney testified that he went to the apartment.
Objection, this is not a question, it's.
Yeah. So you may preface questions just to orient the witness, but to recount testimony with such detail is in the nature of argument and premature argument. So rephrase.
I just wanted to remind, of the testimony of Max Courtney and the photographs of the bullet hole that he found. You've seen that evidence, haven't you?
Yeah,
And is that the bullet hole that was caused by,
spackle.
no, hold on. Was that the bullet hole that was caused by Morris Black shooting at the eviction letter?
Yeah,
And is that the repair job that Morris Black did after he shot the gun?
yeah.
Did that more or less patch things up with you? Between you and Morris?
Well, we had more or less patched things up before then.
All right. Was there another occasion when Morris Black shot the gun in the apartment?
Yes,
Would you explain to the jury what happened that time?
about a week after the first time, I had done something in Houston and came back. And when I got back, Morris was in the apartment. And he was showing me how he could take the gun apart. I told him I did not want him to take the gun apart. And he should put it back together. So he put it back together, and then to show me that he had put it back together correctly, he shot it at a box that was in the kitchen.
What kind of box?
I think it was a box that the TV had come in.
What did you do when he did that? Did you give him permission to do that?
We had the same discussion as we had the first time, that you can't shoot the gun in the apartment.
And what did you say to him?
I said you can't shoot the gun in the apartment.
What did you do with the gun?
Well, we kept the gun in one of the kitchen cabinets.
All right. Now, at some point, you had a nephew that was having a wedding in Houston, correct?
Correct, my sister's son.
When was that?
I think it was like 10 days after 9/11.
So in the middle to the late part of September?
Yes,
By that time, were you living full-time in the apartment in Galveston, or were you living in a hotel, or what were you doing?
I had told the landlord that I was going to give up the apartment, and when I was in Galveston, I was staying at the San Luis Resort, a big hotel on the beach.
How did you register at the San Luis?
I gave them my driver's license
As Bob
and
Durst?
my Amex card, and I registered.
So, did you register as Bob Durst?
Yes,
Did you use your driver's license as Bob Durst?
yes,
Did you use your American Express as Bob Durst?
yes.
And what was the situation with cashing checks at the Bank of America in Galveston at that time?
I was withdrawing cash frequently.
Under your name,
Yes,
your bank account?
yes.
What would happen when you went to the teller to write a check?
She would ask for the Bank of America debit card and my license, and then she would give me money.
Would you have to write out a check?
Usually I used a withdrawal. Either I wrote a check or I did a withdrawal.
In evidence here are several checks in the last part of 2001. Bank America cashed it, the Galveston branch, as Robert Durst. Are those the withdrawals you're talking about?
Yes,
So, in the late summer and fall of 2001, leading up to the end of September, were you openly living as Bob Durst in Galveston?
when I was in Galveston, yes.
And Morris Black knew that you were Bob Durst.
He had known I was Bob Durst for a long time.
All right, you went to your sister's son's, your nephew's wedding in Houston.
Correct.
When did you go?
It was about 10 days after 9/11. Call it 9/21 or something like that,
All right.
whenever the weekend was.
Where did you stay in Houston?
I stayed at the Four Seasons Hotel in Houston
How did you register?
as Robert Durst.
And did you see members of your family?
I saw my sister and her children, and Douglas and his children. I don't think anybody else went to the wedding.
Was it the wedding smaller because of 9/11 and the shutdown?
Yes, half the people Wendy expected to go to the wedding had called and said they did not want to fly.
All right. Nonetheless, did you, did you make some purchases in order to go to the wedding?
Well, Wendy was making this big cowboy thing. So the theme of the wedding had something to do with cowboys, presumably because the bride was from Houston. So I bought a Western shirt with various scribblings on it. And I bought boots.
All right. And so was that the wedding night, or was that the night before the wedding?
Both.
Okay. Did you buy anything at Brooks Brothers for the wedding?
I bought a suit.
Okay. So you didn't wear the Western shirt to the wedding?
Objection, relevant.
No,
You may answer.
I wore the cowboy shirt and the cowboy boots and the Brooks Brothers suit.
Okay. You wore boots with a suit?
Yes,
Objection, relevance, and 352.
probably not as fancy as yours.
Okay, we'll allow that. It'll make us all smile. Imagine that, suit and boots. All right, ladies and gentlemen, it is the noon hour. We come back at 1:30. Do not converse among yourselves or with anyone else on any subject connected with this case. Do not form or express any opinion on